Good morrow and welcome back. You're on and listening to Yucatho Audio, where there's good transmitting through the whole of the stage. Now, in this one here, well, let me go ahead and make something clear because I don't think I had made this clear yet. History boils down to being, and it is a supreme form of mind control. That's what it is, and the Mandela effect that's what it is. Okay, so I'm bringing you one of these old school Mandela effects, that shows you exactly what it is. It's how it's he who controls the narrative. If he's writing the story, then he controls the whole shebang. You see what I mean? He's manipulating all the thought processes because he's got control of the input. You know, you're not going to be any more. You're not going to have any more knowledge than the available information. Now, Section 8, Clause 1st. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States, but all duties, imposts, and excises shall be uniform throughout the United States. This clause, divided by the semicolon, does not confer upon Congress two separate powers: one to lay and collect taxes and company, and the other to provide for their general welfare. But it is the grant of one power, viz. To lay and collect taxes and company, limited by the object, which is for the purpose of providing for the general welfare. Now see, that goes hand in hand with what I'm saying. You are the government. You see what I'm saying? Like when they deposit that mail in your box, that's how they're providing for your general welfare, and it's limited. You're not. There's only so much mail that you're gonna be able to get. You see what I mean? You're not gonna be able to. It keeps everybody honest to a degree. You know what I mean? And keeps everybody within. Where you can't. You're not gonna be able to just cake up like that. It limits it. It puts a tail on there, and that's what you need. That's what it's all about. Now, taxes are two kinds: direct and indirect. Direct taxes are all burdens imposed immediately upon the person or estate of the citizen. Thus, a tax upon houses, lands, money, and company is a direct tax. Indirect taxes are the burdens imposed upon articles of consumption, and chiefly upon imported articles. Thus, the revenue or duty levied upon each yard of broadcloth or cotton sheeting brought to this country from abroad is an indirect tax. Indirect taxes increase the price of imported articles, and thus act as a burden upon those who purchase them. The difference between the two modes of taxation is this: direct taxes act directly upon the person and property of the citizen and is independent of his will. Indirect taxes, by being imposed upon articles imported from foreign countries or used in consumption, leave the people at liberty to pay them or not by using or not using the articles upon which they are imposed. Thus, a farmer cannot avoid the payment of a tax levied upon his land, but he may avoid the payment of the duty upon coffee by not using it. And previous to revolution, such was the fact, as we all know, in relation to the duty upon tea. The people, by patriotic impulse and common consent, abstained from the use of tea, and thus prevented the levying of the duty. Now, what did he just tell you? That the Boston Tea Party is a fucking Mandela effect. Because he just told you that, as we all know, relating to the dirty on tea. We said, fuck your tea. We don't want to drink none of that poison any fucking way. Because we know you poisoned it. So, keep it. We not buying that shit. There was no damn tea party. They made that shit up for you, man. Hey, do you think, I mean, that you take it, I mean, what, this book was, this is like, 1849 or thereabouts. I mean, come on now. I'm gonna take this mug's word for it. I'm gonna go ahead. This sounds legit enough to me. And hey, I wasn't planning on doing it, but I'm gonna give you something. I'm gonna give you a little bonus piece here. Now, okay. It must be right here. Okay. It is stated on high authority that the obligation may exist independently of positive law and be perfect without a remedy. The examples given, however, do not appear to confirm the principle laid down. Thus it is said that a state may have taken away imprisonment for debt, and the debtor may have no property, but still the right of the creditor remains, and he may enforce it against the future property of the debtor. So a debtor may die without leaving any known estate or without any known representative. In such cases, we should not say that the right of the creditor was gone, but only there was nothing on which it could presently operate. But suppose an administrator should be appointed and property and contingency should fall in, the right might then be enforced to the extent of the existing means. What does that mean? I'll tell you what that means. That means they transmuted your ass, and they call that alchemy, baby. They turned you into gold. That's what that says to me. That's what it sounds like to me. It sounds like they turned your ass into gold, and you don't know it. Now let's read a little further, see if I'm wrong. Let's see if I'm onto something here. These examples are cited by the learned commentator to show that right may exist without a remedy, with due deference to an opinion which is at once authoritative and respected. It is thought that he has, in these examples, manifestly confused the remedy given by the law with the object upon which that remedy acts. What is a remedy at law? We are told by an authority, at least as high as the one above cited, that the law consists of several parts, one declaratory, whereby the rights and wrongs are clearly classified and laid down; another directory, whereby the subject is instructed to observe these rights and abstain from these wrongs; a third, remedial, whereby a method is pointed out to recover his rights or redress his wrongs. Here, the remedy in law is defined to be the method whereby a man may recover his rights or redress his wrongs. Now, in the example first cited above of a debt, the remedy or the method given by law is first the action of debt, next the judgment upon that action, and lastly the execution under that judgment. Now, the personal property of the debtor constitutes the object upon which that remedy acts. Both may be out of reach of the remedy, and yet the remedy exists and be perfect at law. It is not perfect in its consequences, merely because other circumstances disconnected from the remedy have prevented that remedy from attaching to the object. The remedy in the example above stated attaches to the property. That property, by one of the conditions of human life, whether poverty or misfortune, does not exist. Here then, the right to a remedy is perfect. The remedy itself, its action, judgment, and execution is perfect, but the object upon which the remedy is to attach is out of reach. The case is the same in the second example of an intestate dying without an estate or representative. The municipal laws of almost every civilized state either require that the probate court should appoint an administrator or give power to the creditor to have one appointed. The administrator being appointed, the second example is precisely the same as the first. The administrator, as a representative of the intestate, is the debtor, and the right, remedy, and the object the same as in the other case. The remedy here spoken of is the remedy at law. The circumstance of the existence of property or not on which the remedy can attach is one which constitutes no part of the remedy at law, for it is obviously one which no human law can regulate. If human intelligence could have devised a means by which the debtor should always have property to answer the demands of his creditor, it would be an act of wisdom which never would have been neglected. Let me read that to you again. If human intelligence could have devised a means by which the debtor should always have property to answer the demands of his creditor, it would be an act of wisdom which never would have been neglected. We may conclude then that if a right can exist without a remedy to enforce it, these are not examples of it. Are there any other examples, either real or imaginary, by which such a principle can be illustrated? The meaning of the term obligation always implies a power to enforce it. To oblige is to compel. So that means they don't have no choice, man. According to Justice Blackstone, the strict sense of obligation is such a constraint as makes it impossible for a man to act otherwise. I mean, they do not have a choice. Civil obligation, then, consists in the remedial power of enforcement. This seems to have been the opinion of several eminent judges in the celebrated case of Ogden v. Saunders. In that decision, the judges gave their opinions seriatim, and in respect to the obligation of contracts, as well as several other points, were widely different in their judgments. These questions are, therefore, far from being settled, although the decision upon the facts of that case is doubtless permanent law. Justice Washington said that the obligation of a contract is a law which binds the parties to perform their agreement. While he admitted that the common law of nations, or the moral law, might form a part of the obligation of a contract, he insisted that this law is to be taken in strict subordination to the municipal law of the land where the contract is made, or is to be executed. Justice Thompson said, "For it is the law which creates the obligation, and whenever therefore the lex loci provides for the dissolution of the contract in any prescribed mode, the parties are presumed to have acted subject to such contingency." Justice Trimble said, "It may be fairly concluded that the obligation of the contract consists in the power and efficiency of the law, which applies to and enforces performance of a contract, or the payment of an equivalent for non-performance. The obligation does not end here and subsist in the contract itself, propria vigoria, but in the law applicable to the contract." This is the same, I think, in which the Constitution uses the term obligation. Chief Justice Marshall then said obligation and remedy then are not identical. They originate at and are derived from different sources. It would seem to follow that law might act on the remedy without acting on the obligation. And that's, I mean, they break it down for you just as simple as you can possibly get it, because enough of these dicta have been cited to show that while the majority of the court agreed in the decision which was made, the individual judges held very different opinions upon the main question, the obligation of contracts. The next question in respect to the impairing of obligation of contracts arose in respect to the insolvent laws of several states. The principal cases upon this point are those of Sturgis versus Crown and Shield, McMillan versus McNeil, and the case just cited, Ogden versus Saunders. The substance of these decisions has already been given in another place. The next decision on this subject was in regard to grants, and in the case of Tarrant v. Taylor, the Supreme Court decided that a legislative grant competently made vested an indivisible and irrevocable title. The state cannot revoke what is once granted away, nor can the legislature repeal statutes creating private corporations and divest the rights under them without the consent or default of the corporators. So basically, I mean, your corporation, they can't take it away. They can't do nothing with it. Now, I think that pretty much that sums up what I was trying to get to. That was the goods right there. You've been given property that you don't understand how to use it, and they know that. So that's why they lock your fucking ass up, and they tax your number. That's what they do. I mean, they make $1 trillion a day on the damn prison system. Look up CRIS, Court Registry Investment System, and it'll tell you all you want to know about the prison industrial complex and what's really going on. They make $1 trillion a day on the stock market trading. I mean, because that's the coupon bond, the DIY bond shit that I did a few videos ago. That's what that's all about right there. Like Jan Keating said, if you don't buy that case, if you don't put something up and get and cover that charge, somebody's gonna buy that fucking warrant that's on your ass, and they're gonna sell that shit on the stock market, and they're gonna make money off your ass, and that's why they're holding you. You need to know this. You need to pay attention. I mean, because every episode I'm gonna come up on here, man, I'm gonna kick the doors down, and I'm gonna give you something that you can take home with you, and you know, I got a chicken for every pot, man. Yeah, that's how we do it. The Calvin Coolidge motherfucker. We got chicken for every pot. So tune in again and again, and keep. I mean, we Culture Quest. That's what we're doing here. We're going to figure out how to do it. Until next time, keep your head up.